Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019, so it's not like you were young and you've learned something and, Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions, entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from the state.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors, anyway, are trespassing cases. And I would guess, and Mr. Johnson tells me this is the case, that most of those, because he was homeless, didn't have any place to go. And as the court knows, if you're homeless and don't have any place to live, you're going to probably pick up some trespassing cases. He does have 2 prior cases where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000. And the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities, $72 worth, which would ordinarily be a misdemeanor, but with the fact that he already has the 2 prior theft cases, and the other felony case was bumped up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003, it looks like, 23 years ago. He tells me that prior to being arrested, he was working for a church, getting paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation. A deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety. In my opinion, the PSI reads as if he expressed interest in that. I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize. Mr. Johnson did want to speak to just so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it when she took my kids to Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. One thing about me, I live and learn. But 2 things happened. As I was doing what I was doing, I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is, it's better to work than to be doing all that. It's a different way that I'm going to go by doing things this time,
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be, the worst I could do today is give you 5 years in prison if I sent you to prison.
Wow.
You'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Well, probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir.
Thank you.
Thank you. No fine. Good morning. Are you Efrain Dinkin?
Yes, ma'am.
And this is cause number 19-32080. And Mr. Dinkin was previously in court, entered pleas of true, and a motion to adjudicate pled true to counts 1 through 5. And the agreement was for a cap of 10 years. I've received the updated report from probation. Have you both had an opportunity to review that report?
Yeah, they have judges.
Any additions or corrections? All
No, not from the state.
right, then you may proceed, Mr. Lewis.
Judge, as far as this situation, Mr. Dinkin, moving with Mr. Dinkins, we know it's a big ask. He is asking that the court consider keeping him on probation, maybe amending his conditions.
Well, first of all, I can't continue him
Okay,
because his probation expired in 2024. So the only option would be to revoke him, sentence him to time on a straight probation. That's the only option other than regular time.
well, let me rephrase that, Judge.
Okay.
We understand that, okay, even if he is the conviction, he does take the conviction and he goes to a straight probation. What Mr. Dinkins is asking for is the opportunity to get the help through probation that's available to him. He know he is messed up, and there's times that he hasn't in the past taken taking those opportunities that was available to him. He's more than willing to try to do that for us, the anger management and the things of that nature. He's trying to better himself. He's a lot older now, to where he can kind of really realize where he is in life and what he wants to do with himself going forward. He knows that probation can help him. He understands that, if given that opportunity, it would probably be only one opportunity and it'd be a zero tolerance type situation. And that's what he's asking for, Judge.
All right. Thank you, Mr. Lewis. Mr. Smith?
Judge, I would disagree. I think revocation, he had a chance at probation. He absconded. He did nothing. We have no idea what he had been doing for that time. And so I feel like PDC time is appropriate in this case. He was given a chance by his own choices. He believed that.
So, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019, so it's not like you were young and you've learned something and, you know, you were a kid when this started. You started testing positive for cocaine back in 2022. You were referred to the ATAR substance abuse program, did not comply with all of those directions. So you were given help. Then another administrative hearing was had September of 2022. You tested positive again for cocaine. Even though you had previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF and you never showed up, and you've been gone ever since. So I don't know what other options or things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can go back with the bailiff.